I'm Ben Meiselas from the MeidasTouch Network. The disqualification case that could remove Donald Trump from the ballot in Colorado is indeed proceeding to trial after once again the Colorado judge presiding over the case, Second Judicial District Judge Sarah Wallace, wrote an opinion that just ruled that Donald Trump's motion to dismiss is denied. That means the case, folks, is going to trial. Of course, the United States Constitution 14th Amendment has a section specifying that anyone who has engaged in insurrection or rebellion or who has given aid or comfort to those carrying out an insurrection cannot run for office. The petition to disqualify Donald Trump was filed by a group we are big fans of here at the MeidasTouch Network called CREW. Their president and their general counsel has spoken with us many times. The Citizens for Responsibility and Ethics in Washington, or CREW, filed the petition back in September on the 14th Amendment disqualification grounds. You'll recall that we covered when Judge Wallace denied Donald Trump's prior motion to dismiss, where Donald Trump asserted that based on the anti-SLAPP statute in Colorado, which is strategic lawsuits against public policy, that based on a First Amendment argument, Donald Trump tried to argue the disqualification case should be dismissed. About a week ago, Judge Wallace denied that motion to dismiss. There was this remaining motion to dismiss that Donald Trump still had pending. And you'll recall one of the arguments that Donald Trump made was that the oath to the Constitution, he claims, did not apply to him. That's right. If you go to Donald Trump's motion to dismiss brief that he filed, he argued that Section 3 does not apply to all officers of the United States, but only those who take an oath, quote, to support the Constitution of the United States. As explained there, the presidential oath, which the framers of the 14th Amendment surely knew, requires the president to swear to preserve, to protect, and defend the Constitution, not to support the Constitution. So one of Donald Trump's arguments was that he did not take an oath to, quote, support the Constitution, and so therefore the 14th Amendment disqualification clause does not apply to him. I want to give a hat tip, by the way, to Judge Wallace, because she did something very smart in her order denying Donald Trump's most recent motion to dismiss on these procedural grounds and on more substantive grounds. She cited in her order Supreme Court Justice Gorsuch's opinion, where Gorsuch found that state secretary of states have the right to disqualify people who don't belong on the ballot or who are trying to unlawfully present themselves in a specific state. There was a case called Hassan versus the state of Colorado, and this found its way to the 11th Circuit Court of Appeal before Neil Gorsuch, now a Supreme Court justice. At the time of this opinion in 2012, he was Judge Gorsuch. He was a Court of Appeals judge for the 11th Circuit, as well as other circuit judges. And here's what Judge Gorsuch ruled back in 2012. Abdul Karim Hassan is a naturalized citizen who wishes to run for the presidency of the United States. This even though the Constitution says no person except a natural-born citizen shall be eligible to the office of the president. Abdul Karim Hassan is a naturalized citizen who wishes to run for president, even though the Constitution says that. After the Colorado Secretary of State informed him that his ineligibility for office precluded placement on the ballot, Mr. Hassan brought this lawsuit asserting that the natural-born citizen requirement and its enforcement through state law, barring his access to the ballot, violates the Citizenship, Privileges, and Immunities and Equal Protection Clause of the 14th Amendment. The magistrate judge heard the case on consent of the parties and eventually concluded that the 14th Amendment did not affect the validity of Article 2's distinction between natural-born and naturalized citizens. We affirm we discern no reversible error in the magistrate's disposition and see little we might usefully add to the extensive and thoughtful opinion he issued. To be sure, Hassan contends the magistrate judge overlooked one aspect of his claim. Hassan insists his challenge to Colorado's enforcement of the natural-born citizenship requirement did not depend exclusively on the invalidation of Article 2 by the 14th Amendment. Even if Article 2 properly holds him ineligible to assume the office, Mr. Hassan claims it is still unlawful and an act of discrimination for him to be removed. And then Judge Gorsuch, now Supreme Court Justice Gorsuch, found in 2012 that no, the Secretary of State of Colorado was within their rights to remove him from the ballot. So here, Judge Wallace, in the Trump disqualification case, knows that this is likely going to go to the Supreme Court, so cites that Gorsuch decision and basically analogizes it to the 14th Amendment Section 3 disqualification clause of the United States Constitution and says, look, here's the plain terms of the language: engaged in insurrection or rebellion or has given aid or comfort to those carrying out an insurrection. And you cannot run for office. There it is. It's clear. And one of the things that Judge Wallace also said is that in the motion to dismiss is that this case is going to trial. Trial's October 30th. Trump, if he wants to make his argument that Section 3 of the 14th Amendment doesn't apply to him because he didn't give an oath to support the Constitution, make that argument then. We're not granting a motion to dismiss at this stage. And just like in the Hassan case, the Secretary of State is well within its powers to remove people who are constitutionally infirm. One of the other things that the petitioner's crew has requested is Donald Trump's deposition. That has not been ruled on yet as well. So this disqualification case, folks, is going to trial. It's going to trial in the next less than 10 days. So that's pretty big, in and of itself. And then one of the things that the judge also addressed was the fact that the Republican Party of Colorado tried to claim that it has the right to intervene. The Colorado Republican Party Central Committee said that they have the right to decide whoever it is that they want on the ballot. And if they want Donald Trump on the ballot, that overrides the Secretary of State. No, says Judge Wallace, again citing federal and state court precedent, and then citing the applicable electoral code statute in Colorado that stands for the proposition that this is within the province and right of the Secretary of State. The legal framework set forth is that the Colorado Secretary of State is charged with the duty to preserve the conduct of primary, general, congressional vacancy, and statewide ballot issue elections, and to enforce the provisions of the election code. When a dispute regarding the application and enforcement of the election code arises, it goes through this current procedure that's now before the judge, and the electoral code is the exclusive method for the adjudication of controversies arising from a breach or neglect of duty or other wrongful act that occurs prior to the day of an election. A valid, verified petition is filed, there's a response, and then it goes through the current process that it does. So that is where we are at right now, folks. We will keep you posted as we learn more, but the Colorado disqualification case is going to trial. Judge Wallace clearly knows that this will probably eventually get to the Supreme Court. She's already citing Justice Gorsuch as support for what she is doing. We'll see if the petitioners get a deposition of Donald Trump before October 30th. We'll see if Donald Trump shows up to testify. It'll be interesting if he refuses to show up, and by refusing to show up, or if he invokes his Fifth Amendment right against self-incrimination, would that serve as an adverse inference against him? But everyone, I think, will start focusing a lot more on this disqualification case soon as it's going to trial, and so I wanted to give you the latest update. So just in quick summary, Donald Trump filed a prior motion to dismiss called an anti-SLAPP motion to dismiss, claiming the First Amendment allowed him to do what he did and he can't be challenged. Judge rejected that over a week ago. Trump had another motion to dismiss pending, as did the Republican Central Planning Committee of Colorado. The judge rejected that. Crew, the organization, they've asked for a deposition. We're waiting on that ruling from the judge. Trial October 30th. That's all you need to know right now about the disqualification case. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We are on our way to 2 million subscribers thanks to your incredible support. Hit subscribe right now. Thank you.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.